Hello out there and welcome to Boomer Time. I'm your host, Nancy Cogar, and if you've been here before, been around here for a while, you know that I'm an attorney with an elder law and estate planning practice here in Tennessee. Aging is not easy, right? And that is why Boomer Time is here each week to focus on the often complex issues that come up as we age. It's my hope that you will not only better understand these issues, whether you're a caregiver or even an aging adult, but that this will motivate you to better prepare. That's really the bottom line, right? We've talked about issues that involve typical estates, but what if you have a healthy estate, one that is more plentiful than others? Those are called high net worth estates. And today we're going to talk about what constitutes a high value estate, right? What they may look like, what kind of assets may be involved, and the risks that can come from not having an appropriate plan. And as that's the case, I'm going to bring up some real life examples that I hope will bring some of this to life for you out there. So, first of all, what is a high net worth estate? Right? How much money makes a high net worth estate? Well, let's start with a definition, okay? So, a high net worth estate isn't just about yachts and jewels and trust funds. If your estate, the whole estate, real estate investments, retirement accounts, and any other assets exceeds $1 million, well, you may find yourself in a category of high net worth estates. And this also means that you should pay attention to tax issues, exemption issues, all these things. On the high end of a high net worth estate is the current federal estate tax exemption. Okay, this means how much you can keep or claim before you're subject to tax. That's an important issue, don't you think? Well, in 2025, it's $13.9 million per individual. That also comes up to just under 30 million for married couples. Right? You're thinking, how does this have anything to do with me? Well, the numbers are expected to sunset or expire at the end of this year. So if that happens, they're going to roll back. And that means it could bring more of an impact to more people. It could bring it down to $6 million. That's a drastic impact. And you may be potentially impacted, if you consider all of those things. So what do? If your entire estate exceeds that amount, you're going to be subject to estate tax at the federal level. And that amount could be taxed at up to 40%. 40%. Paying attention to those state levels is important too. So here in Tennessee, we currently don't have an inheritance tax. There's no tax. Okay, it lapsed about a decade ago and the legislature never brought it back. That doesn't mean that will always be the case, right? They could change. But it does, for now, make us a very attractive place to spend your later years for obvious reasons, right? Tennessee did have a threshold amount prior to that of $1 million. So that means anything under that amount was not subject to estate tax. Important to note, though, income tax, any kind of income that's generated by an estate during administration is also subject to tax, but that's income tax. So if you've got a lot of money or you've got a lot of assets, even if you don't have cash, these are things you need to pay attention to, or you could get, bit in a way you're not really expecting. So now that we've defined it, let's, talk about what can go wrong when these estates aren't planned properly. And how do you prevent that? Well, I wanted to bring up a real life example, okay? And it has to do with something called liquidity. So one of the biggest traps for high net worth estates is a lack of liquidity. Well, Nancy, what does that mean? It means if you've got a lot of stuff, but it doesn't include a lot of cash, then you could be in trouble, especially if you're lacking in cash to cover those estate taxes and expenses associated with administration of your estate. I've seen this issue come up in cases where someone has a large real estate portfolio, numbers of houses, but there really is no cash, no liquidity. So maybe there's equity in some of those houses. And in order to get the cash, action has to be taken to liquidate that equity. That means a sale of the property. So here's one scenario where that same issue took place. Okay, take James. James was a successful real estate developer. He had a large real estate portfolio. The whole thing was worth, about $10 million. It gave him a lot of leverage to be able to borrow against that and buy more houses. Well, this would definitely qualify as a high net worth estate, right? The problem is nearly all of James' assets had been invested, in the purchase of the real estate, apartment buildings, single family homes, vacation homes. So when he passed away, his two children who survived him were left with managing the estate that he left behind, and unfortunately quickly learned that he did not have enough cash to cover the $1.6 million tax bill. And that meant that they were forced to sell one of the most loved properties that the family had. It was a beach house. And, timing, it was a down market. So they were under a tight deadline because they had to pay those taxes. So the sale was rushed and it was painful. And worse still, one child wanted to keep that house. So they were brokenhearted. The other wanted the cash, which led to family tension, of course, right? End result, the house was sold for a lot less than it was probably worth and what it would have sold in a better market. But, you know, other issues were related too. So if this was the homestead, you could preserve a step up in basis to save on potential tax liability. But if you do nothing, selling assets within the estate can trigger capital gains tax. I'm talking about a lot of taxes, right? This is complicated. But the lesson here, real estate, heavy estates, must plan for liquidity. You have to have some cash, either through, you might consider life insurance policies that are benefits to the estate, trusts, or planned asset sales. What are you going to sell first and when? Otherwise, the family might lose far more than just money. So another note about owning property or investments in multiple states or countries that I think is important to bring up is that it absolutely complicates estate administration due to, the different legal and tax regulations. Different states have different laws when it relates to administration. So the real estate where the property is located has the jurisdiction over that property. It's called in rem jurisdiction. For your purposes, what that means is you may have to hold a second probate or an ancillary probate where that property is located. So that means more time, more expense. You don't want that. Interesting stuff, huh? I'm going to take a quick break, and when we come back, we're going to talk about more kind of things that may come up with high net worth estates that, you may have be impacted and not even realize it. Be back. Well, welcome back to Boomer Time. Let's shift to family-owned businesses. I know there are a lot of you out there. This is a big chunk of high net worth estates, whether you realize it or not. And often it can become a real source of conflict if the planning is vague. So I'm talking to you out there. If you've got a small business and you don't have a succession plan, you don't have your business plan included in your estate plan, you need to do something about that. Okay, the primary type of business is a small business, right? Our communities are made up of small businesses. And you might be surprised how few of the small business owners out there include businesses as part of their estate plan. So here's another example. Take Margaret. She owned a logistics company. It was valued at about $8 million. That includes her gross estate, so she's a high net worth estate. She had three adult children. One ran the business, one had absolutely no involvement, and the other, the third, was estranged, wasn't communicating with the family for whatever reason. Well, Margaret died without a business succession plan. Her will simply left everything equally to her three kids. The child running the company thought they'd continue to operate it, right? Well, the other two didn't agree. The others wanted to cash it out, liquidate it, close it immediately. The court appointed a receiver. That could happen right here in Hamilton County, does all the time. Legal battles ensued over the disputed thoughts about what should happen with the company. People who were owed money from the company, undone business. And this company, which was once thriving, had to be sold, and it lost a lot of money. So businesses and partnerships can add a lot of complexity to estate administration. So these require careful evaluation and consideration. Have a succession plan involved with your business. Business owners have to plan early, have those buying sale agreement. Talk about whether your business is going to be sold. Find out how much it's worth. Plan to put it into a trust. Who's going to continue to operate it? How do you do that? Structure a transition plan. You need to make sure that the company survives, especially if people are relying on you, as that's their means of income. The second part is you need to make sure your wishes are respected. If you don't put a plan in place, you're just leaving that to chance. Well, here's another that I see all the time, and that is blended families. Families, second marriages that bring, things from the previous marriage to the table. So there's his and her assets. Like I said, I see this all the time. Adults in a second marriage bringing two backgrounds, assets, and families, personalities, right, into the new marriage. This absolutely requires special planning, or otherwise, you might see the D word, disaster, disaster. You thought I was going to spell the other D word, didn't you? That could happen too, but remember, someone's already passed away, so I don't want you to have a disaster. We want to prevent that from happening. And without planning, blended families are just ripe for disputes. So take Ronald. He had two adult children from his first marriage, and then later in life, he married Susan. He had always told his kids they'd inherit the family's lake house. That was the promise. But he didn't write it down. He never updated his estate plan to reflect any of that. So when he died, the beach house or the lake house automatically passed to new wife Susan as the surviving spouse under state law. Susan decided not to share the property, and Ronald's children were devastated, and legally, there wasn't much they could do. I have seen this before, and it can work the other way. No will. One holds the real estate interest, the other doesn't. At death, the kids from the deceased's previous marriage may take what otherwise was the marital home. Sounds crazy, right? But I have seen it. Lesson to be learned: in blended families, verbal responses are not enough. If you've been around here, I say if it's not written, then forget it. It's not worth it. But verbal promises here are especially not enough. You need to put your wishes in writing, ideally through updated wills, trusts, even prenuptial agreements, seeing more of those. This will protect you and your spouse and your children. Just a note about grandchildren. If you have a sizable estate where it's possible that it could benefit several generations, you might want to look at the generation skipping transfer tax. That's a tax that applies when assets are transferred to individuals in 2 or more generations younger than the donor. So your grandchildren, right? Great grandchildren. Managing the implications of that takes careful planning too. There's all kinds of things, aren't there? And this is just for estates over $1 million. So a lot more of you out there than I suspect you really realized. And that includes real estate, cars, assets, retirement accounts, investments, all of it together. Doesn't take long to get there. I wanted to talk about unique assets and the value of those. So, not all wealth is in bank accounts. Some people have art, some people have collectibles. I like to watch Antique Roadshow and love to see the stuff that comes up there. Jewelry, antiques, strange items that have passed through the family. These, you've seen the show, these can hold tremendous financial and even emotional value. I once saw a family, one lawyer was on the other side, and the kids were fighting over 50-year-old Christmas decorations that had been in a crawl space and were not worth anything. But they were worth something to them, okay? The emotional value. Here's an example for you. Eleanor, who was a lifelong collector, she passed away with a $7 million estate. Much of it was in rare art and antiques. She didn't leave an inventory. She didn't leave appraisals. And her children all had different ideas about the value of the pieces. That sounds likely, right? One of them wanted to keep them. One of them wanted to sell them. The estate ended up tangled in appraisal disputes. One wanted an appraisal. The other didn't like that appraisal and wanted another appraisal. And then there were penalties for underreporting of some of the value. Lesson here, special assets need special planning, okay? Appraisals, written instructions, and even sometimes a professional fiduciary, somebody who manages estates for a living, should oversee distribution. I'm going to talk about probate nightmares. I'm going to just take a quick break, but stick with me on that. It's worth the wait. Welcome back, my Boomer Time family. Hey, I wanted to remind you that if you like the content here, share it with a friend. We need more people knowing about these issues. This is huge. There is really a lack of awareness about these things. And if you like the podcast, like it and subscribe so you don't miss any future episodes. I'd really like to see you do that, so I hope you do. Well, I see more and more folks seeking to avoid probate, and that means not having the court have to direct the administration of your estate. That makes sense, right? Options like trusts can help to do that and, avoid the delays, the costs, the potential claims, all of it. And let's not forget the value, like I said, of being able to convey those assets on your own time with your own directions. Problem is, some people never take the time or make the investment to set up a trust, and it doesn't have to be as complicated, as you think it might. So take Linda. She had a $12 million estate. So she had a basic will, but she never thought to set up a trust. She thought that could wait. After her death, her Her estate went through a long public in court, right? And expensive probate. What's worse, a distant cousin contested the will. What are the chances of that? Well, it's possible. So that delayed distribution for over a year. Of course, this distant cousin would have to prove that they had standing or the ability to challenge something in court and possibly set it aside. But I've seen it, and it may be that the state law would control if he set aside the will, and that would open it up to him and more distant family members or heirs at law, possibly. Well, the children, they spent tens of thousands of dollars in legal fees and had to account for every detail through the court system. Lesson: a revocable trust can help avoid probate entirely, can keep things private, and dramatically reduce the chance of a contested estate. And it's private. So you might want to consider that. I have a lot of people doing that now. So now, what should you do and what can you do today to prevent some of these issues from coming up? I would say first, you really need to evaluate your estate, including any kind of small business interests, real estate, and those investments. How much is your estate worth? Like I said, it doesn't take long to go over $1 million, and that puts you at that high net worth category. What are some of the potential issues you may face? You can also plan to avoid those, but guess what? You have to plan, right? You can use annual gifting and try to lessen the value of your estate. You may receive a benefit through those strategies. Use trusts, like I said, for real estate or business interests, or to provide distributions to heirs over a longer period. I see that. Think about liquidity, right? Cash. What cash is available? Will your estate have the cash to cover taxes and expenses? Think about a life insurance policy that can be added to the estate plan to provide that cash of your death, right? Review your plan regularly, especially after any kind of marriages, births, deaths, moves, business changes, or significant health changes, any of that. Call me for a strategy session. I can talk to you about your concerns, offer options. It really doesn't make sense not to take action. After all, you want to make sure, I think, more of your hard-earned assets go to where you want them to go, right? And not to satisfy some liability that you may have to the government. If there's one takeaway, it's this. The more wealth you have, the more planning you need. Okay? The more wealth you have, the more planning you need. And not to complicate things, I mean to simplify them for you and your loved ones, and protect that legacy that you've worked so hard to build. So has this been helpful today? I bet it's raised some questions. Do you have a story to share that might help others with this very issue? Let me know. Reach out, share a comment about the podcast, ask a question, schedule a strategy session, right? You can do all of that through my website, which is nancycogar.com. And if you haven't done it already, like I said, please like and subscribe to the podcast. You won't miss future episodes, and you're going to help me spread the word about Boomer Time. And I sure do appreciate that. So take care, plan wisely, and age with confidence. That's what I want you to do. So see you next time.